It is just before midnight on May 16th, 2025, in the neighborhood known as Little Haiti, Miami, Florida. The air outside a converted warehouse on Northeast 67th Street is thick with the kind of heat that Miami never quite loses, even late in spring. Inside, the crowd has been loud and electric for hours, pulsing with the energy that comes with underground celebrity boxing, the sweat and the pageantry, the social media streams rolling, the influencer Aiden Ross hosting his latest event. Celebrities orbit the ring. Cameras are everywhere. The whole world, it seems, is watching. Antonio Brown is here. He is 36 years old now, a man who was once the most feared wide receiver on any football field in the country. 7 Pro Bowls, 4 consecutive first-team All-Pro selections, 928 career receptions, more receiving yards in a 4-year span than any player who had ever worn an NFL uniform. The kind of athletic gift that comes along once in a generation, maybe less. The kind of man who once made Pittsburgh roar and Pittsburgh weep, sometimes in the same afternoon. He is also live streaming himself at this very boxing event, which means the world already knows he is here. That fact will matter. And then, in the sticky dark outside the warehouse, it all goes wrong. A shot spotter alert fires somewhere on a Miami Police Department computer screen. Officers are dispatched to Northeast 2nd Avenue and 67th Street. When they arrive, the crowd is fractured, people scattered, voices raised. Multiple witnesses point in the same direction. They tell officers that the shooter was Antonio Brown. Officers find Brown in the parking lot. He does not have a weapon on him. 2 brass shell casings are on the ground nearby. The alleged victim cannot be found. Not yet. Police place Brown in handcuffs, walk him to a cruiser, and in the body camera footage that will later be released to the public, you can see him in that back seat. The former All-Pro wide receiver, a cut near his eye, an injury to his knee, asking an officer to let him use the bathroom, asking the officer to call his mom, asking the officer to look at his knee. Police release him a few hours later. The victim has not been identified. Brown posts to X, formerly Twitter, the following morning. He says he was jumped. He says multiple individuals tried to steal his jewelry and cause him physical harm. He says he was temporarily detained until police heard his side of the story and then released. He does not mention gunshots. 5 days later, on May 21st, a man named Zulkarnain Kwame Nantambu walks into a Miami police station and gives a full statement. He says he knew Antonio Brown. He says they had a long and troubled history. And he says that on the night of May 16th, after a fight that spilled out of the boxing venue into the street, Antonio Brown came after him with a gun and fired 2 shots. One of those bullets, Nantambu tells investigators, grazed his neck. By the grace of God, says Nantambu's attorney later, his client was not killed. On June 11, 2025, a Miami-Dade county judge signs an arrest warrant. Antonio Brown is charged with second-degree attempted murder with a deadly weapon. The maximum sentence, given the firearm enhancement under Florida law, is 30 years in prison. But Antonio Brown is not in Miami when that warrant is signed. Antonio Brown is not even in the United States. He is in Dubai. If you are new to this channel, please subscribe. These stories deserve to be heard. Now let's continue. To understand a man walking out of Miami jail on November 13th, 2025, you have to understand the boy who grew up in Liberty City. Liberty City is a neighborhood in Northwest Miami, a place of extraordinary contradiction. It has produced world-class athletes, musicians, and intellectuals. It has also been the site of some of the most desperate poverty and violent street crime in Florida history. The 1980 Liberty City riots, triggered by the acquittal of 4 police officers who beat a black insurance salesman named Arthur McDuffie to death, left 18 people dead, and the neighborhood scarred in ways that have never fully healed. To grow up in Liberty City in the late 1980s and 1990s was to grow up surrounded by both tremendous human possibility and tremendous human suffering, often at the same address. Antonio Tavares Brown Sr. was born on July 10, 1988, to 2 teenage parents in that neighborhood. His mother was Adrienne Moss, and his father was Eddie Brown, not the famous NFL wide receiver who played for the Cincinnati Bengals in the 1980s, but a different Eddie Brown entirely, a man who would go on to become one of the most celebrated players in Arena Football League history. In 2006, the Arena Football League would vote Eddie Brown the greatest player the league had ever produced. But when Antonio was growing up, his father was largely absent, not missing from the world. Eddie Brown was playing football, building a career, building a name, but he was not in a house on the north side of Miami where Antonio and his younger brother Desmond were being raised. He was not the man who took Antonio to practice, who checked his homework, who sat across from him at dinner. The closest thing to a father figure in Antonio Brown's early life was a man named Edie Smith, known as Bo, an athletic trainer in Liberty City, who saw something in the small, physically unimpressive kid and decided to train him hard. "I broke other guys down," Smith would later say, reflecting on his methods. But Antonio Brown could take it, and then some. There was a fire in him. Antonio attended Miami Norland Senior High School, where he competed in both football and track. He was not a heavily recruited prospect. He was not the biggest or the fastest kid on the field. What he had was an almost pathological work ethic and a hunger that seemed to drive him to outwork anyone around him. He had something to prove, and he knew it. The home situation deteriorated when Antonio was a teenager. His mother had remarried, and Antonio could not abide his stepfather. The friction in the house was constant and escalating. When Antonio was 16 years old, his mother made a decision that no parent makes lightly. She kicked her son out of the house. He was 16. He was on his own. He bounced from house to house, staying with teammates and friends, scraping together odd jobs to keep himself going. The experience of homelessness at 16, of having no safety net, no reliable roof, no parent to call, it would mark Antonio Brown in ways he never fully shook. It made him hungry for success with an intensity that bordered on obsession. It also, perhaps, planted the seeds of a man who trusted very few people, who felt deeply that the world owed him something, and who always had one eye on the exit. When it came time for college, Brown was not in high demand. He applied to Florida State University, which rejected him over academic concerns. He tried Alcorn State. That didn't work out either. He enrolled briefly at North Carolina Tech Prep before managing to get himself into Florida International University, and then lost that scholarship before the season even began, reportedly for a confrontation with the university's security staff. It is a remarkable resume of near misses and fresh starts. Most people stop at one or two of those walls. Antonio Brown, whatever his flaws, was not most people. He eventually found his way to Central Michigan University, where he would play for Coach Butch Jones and where the story of Antonio Brown, football player, truly began. At CMU, he became one of the most productive receivers in the MAC Conference's history. He set school records with 305 career receptions and was fourth all-time in receiving yards with 3,199. In his junior season alone, he had 110 receptions for 1,198 yards and 9 touchdowns, helping Central Michigan to a school record 12 wins, including the MAC championship. He was also named a first-team All-American, not as a receiver, but as a punt returner. It was a detail that said something about how scouts saw him. Talented, shifty, explosive, but perhaps not the polished route runner who could step in and dominate at the NFL level. Brown decided not to return for his senior season. He entered the 2010 NFL Draft. Most analysts projected him as a 5th or 6th round selection. He was ranked the 37th best receiver in the draft class. He was invited to the Combine, where his numbers were considered unremarkable. He went to Central Michigan's Pro Day and worked hard to improve his times in the 10, 20, and 40-yard dash. He improved in all three. On draft day, Brown sat and waited. He waited through the first round, the second, the third, the fourth, the fifth. The Pittsburgh Steelers finally selected him in the 6th round with the 195th overall pick. He was the 22nd of 27 wide receivers chosen. He was the second receiver the Steelers took, behind a kid named Emmanuel Sanders. He chose jersey number 84. When asked why, Brown explained, 8 times 4 is 32. 32 teams look past me, even the Steelers. So every time I go out there, it's a little added motivation. That number, that sentence, they told you everything you needed to know about Antonio Brown. He had been overlooked his entire life, by his father, by his coaches, by the universities that wouldn't take him, by 21 NFL teams. He ran on that fuel. He burned with it. The question that the next 15 years would slowly, painfully answer was this: what happens to a man who can only be driven by the feeling of being wronged? What happens when the accolades arrive, when the contracts come, when the fame settles in, and the hunger for grievance remains long after there is anything left to prove? Pittsburgh, Pennsylvania, 2010. The Steelers are coming off a Super Bowl appearance in Super Bowl 43 2 seasons prior, and they are still a team with the muscle memory of championship football. Ben Roethlisberger is at quarterback. Hines Ward is the veteran anchor at wide receiver. The city loves its Steelers with a fierce, possessive love of a place that has been through hard times and holds on to its icons. Into this world comes a 21-year-old from Miami with something to prove. In his very first NFL regular season, Brown made 16 receptions for 167 yards in 10 games. Modest numbers for a sixth-round pick in his first year. But in the playoff run that followed, people started to take notice. The Steelers made it to Super Bowl 45 before losing to the Green Bay Packers. Brown had arrived in the biggest arena in American sports. The real breakthrough came in his second season, 2011. Brown did something that no player in NFL history had ever done. He became the first player to record both 1,000 receiving yards and 1,000 return yards in a single season. That kind of versatility, that kind of production from both sides of the ball, earned him his first Pro Bowl selection. The Steelers took notice. In 2012, they signed him to a 5-year extension worth $42.5 million. And then, as if he'd been waiting for security to finally unleash himself, Antonio Brown became something approaching otherworldly. In 2013, he became the only receiver in NFL history to record at least 5 receptions for at least 50 yards in every single game of the season. Every single game. He was not a volume catcher who padded stats with short passes. He was a precision instrument, shredding defensive backs with route running that looked mechanical in its perfection and physical in its violence. He could separate on the short route. He could separate on the deep post. He could align in the slot or on the outside, and it did not matter. The result was the same. In 2014 and 2015, he led the NFL in both receptions and receiving yards. In 2014 alone, he set new Pittsburgh Steelers franchise records with 129 receptions, 1,698 yards, and 13 touchdowns. The following year, he shattered those records again. 136 receptions, 1,834 yards, 10 touchdowns. He set an NFL record with 4 games of at least 175 receiving yards in a single season. In 2015, the Steelers restructured his contract for the 3rd time in 3 years. He was becoming, in the language of the NFL front office, uncuttable. His 4 consecutive first-team All-Pro selections from 2014 to 2017 placed him in the company of receivers that history regards as transcendent. His 7 Pro Bowl selections, 6 in a row from 2013 to 2018, reinforced the case. In the span of 4 years, there was an argument to be made that Antonio Brown was the best receiver on the planet. Off the field, he was also becoming a personality. He appeared on season 22 of Dancing with the Stars in 2016, displaying an athleticism and showmanship that surprised exactly no one who had watched him celebrate in NFL end zones. He appeared on the first season of The Masked Singer. He showed up in Drake's 2018 music video for God's Plan. He arrived at training camps in custom Rolls Royces. He was not just a football player. He was a celebrity, a brand, a spectacle. But underneath all of it, the cracks were already forming. Teammates and coaches in Pittsburgh will tell you that there were 2 Antonio Browns. There was a receiver on the field who was absolutely merciless in his preparation and execution. And there was a man off the field who seemed to operate by his own gravitational rules. He was legendarily late, not occasionally late, persistently, habitually, sometimes outrageously late. Former offensive lineman Doug Legerski recalled that no one could ever really get mad at Brown for his tardiness, because he always showed up with a big smile on his face. But the smiles grew harder to accept as the years went on. Head coach Mike Tomlin would later acknowledge that Brown would skip practice and become essentially unreachable on some days. These were not the behaviors of a man who was fully invested in the team concept, and they did not go unnoticed. In 2018, the relationship with Roethlisberger deteriorated visibly. Brown missed team meetings late in the season and was deactivated for the Steelers' final regular season game, a move that had never been made for a player his caliber before. The reasons cited were behavioral, a word that covers a great deal of ground. Privately, reports surfaced that Brown and Roethlisberger had a relationship that had curdled over years of petty disagreements, differing personalities, and Brown's growing sense of himself as not just a teammate, but the center of the universe around whom everyone else should orbit. When a teammate said Brown yelled at defensive coordinator Dick LeBeau not to touch him in practice because he was the franchise, it was funny. Then it wasn't. Brown also made headlines in 2018 for an incident at his apartment building in Pittsburgh, where he allegedly threw furniture from his 14th floor window, and some of that furniture struck a 22-month-old child on the patio below. He eventually reached a settlement in that case. The Steelers had enough. In March 2019, they traded Antonio Brown to the Oakland Raiders for a 3rd round and a 5th round draft pick. He had 9 seasons and a legacy in Pittsburgh. He was going to California to start over. He would never start over again. Not really. The road from Pittsburgh forward was not the story of a new beginning. It was a story of an accelerating unraveling. Oakland, California, March 2019. John Gruden is the head coach of the Raiders, a man who had long coveted Antonio Brown and believed he could handle the complexities of the wide receiver's personality. He can run every route you dream up, Gruden said publicly. The Raiders gave Brown a 3-year contract that would make him the highest-paid receiver in NFL history. At Brown's introductory press conference, he smiled for the cameras and said, "I'm here to elevate everything around me. I'm here to just be a surge of energy, of positivity, and good force. A great teammate." He arrived at his first Raiders training camp in a hot air balloon. The season that followed was perhaps the most compressed disaster in modern NFL history. Before training camp was even finished, Brown had gotten frostbite on both feet by attending a cryotherapy session, wearing flip-flops instead of the proper protective footwear, an injury that caused him to miss 10 of 11 training camp practices. Launched a weeks-long crusade to be allowed to wear his old Shut Air Advantage helmet, which had been banned by the NFL because it was more than 10 years old and did not meet updated safety standards. Brown insisted the helmet made him feel safer. He threatened retirement over the issue. He filed grievances. He lost. Had a heated, obscenity-laced confrontation with Raiders general manager Mike Mayock during practice, which resulted in a fine of $215,000 and the voiding of $29 million in guaranteed money from his contract. Secretly recorded a private phone call with John Gruden and posted an edited version of it to social media, in which Gruden could be heard telling Brown to please stop this and just play football. The coach, remarkably, seemed amused rather than outraged. On September 7th, 2019, the day before the Raiders season opener, Brown went to social media and publicly requested his release. The Raiders obliged. In one offseason, without playing a single regular season game, Antonio Brown had managed to alienate an entire franchise, lose tens of millions of dollars, and burn one of the most celebrated contracts in receiver history to the ground. Within hours, the New England Patriots signed him. Tom Brady, who was already a 5-time Super Bowl champion and regarded by most observers as the greatest quarterback in football history, was reportedly enthusiastic about Brown's arrival in New England. Brady even offered to let Brown stay at his home while he looked for a place to live. The Patriot way, the argument went, would neutralize whatever was driving Brown to self-destruction. Brown played exactly one game as a Patriot, catching 4 passes for 54 yards and a touchdown in a Week 2 win over the Miami Dolphins on September 15th, 2019. 4 days earlier, on September 10th, something had happened that would fundamentally alter the trajectory of Antonio Brown's public life. His former personal trainer, Brittany Taylor, a former gymnast who had attended Central Michigan University at the same time as Brown and had known him for years, filed a civil lawsuit against him in the Southern District of Florida. The lawsuit alleged that Brown had sexually assaulted her on 3 separate occasions between June 2017 and May 2018, including one incident she described as forcible rape. Brown's attorneys denied every allegation. They characterized Taylor's claims as fabrications and suggested the lawsuit was motivated by a business dispute between them. Brown filed a countersuit. The NFL opened an investigation. Then Sports Illustrated published an extensive investigative report on September 16th that detailed not only Taylor's allegations, but an additional accusation of sexual misconduct from another woman, as well as a pattern of domestic incidents, unpaid debts, and troubled relationships that painted a picture of Brown's off-field life far more troubling than anything that had previously been public. The New England Patriots released Antonio Brown on September 20th, 2019, 5 days after his only game with the team, and 4 days after the Sports Illustrated report. The Patriots gave no public explanation. None was needed. Brown and Taylor eventually settled the civil lawsuit in April 2021 on undisclosed terms. No criminal charges were ever filed. The Allegheny County District Attorney's Office declined to prosecute, citing statute of limitations issues. But the lawsuit had done its damage. For the rest of 2019 and into 2020, Brown was a free agent with no takers. He posted to social media. He announced a retirement that lasted 4 days. He had workouts with teams that led nowhere. He was suspended by the NFL for the first 8 weeks of the 2020 season for multiple violations of the league's personal conduct policy. October 2020. A phone call was made between Brown's representatives and the Tampa Bay Buccaneers, and something remarkable happened. Head coach Bruce Arians, who had known Brown from their time together in Pittsburgh when Arians was the Steelers' offensive coordinator, believed he could reach him. And on the roster of the Buccaneers, freshly signed from New England, was a 43-year-old quarterback named Tom Brady, who had agreed to try one more time with a man who had lived briefly in his house and who Brady seemed to genuinely believe in despite everything. Brown signed a 1-year deal worth a reported $1 million base salary with performance incentives. He was reinstated from suspension in November 2020 and began playing almost immediately. What followed was one of the more improbable chapters in modern NFL history. The Tampa Bay Buccaneers, led by Brady and featuring a wide receiver core that suddenly included one of the greatest receivers in the history of the position, were going to the Super Bowl. In the NFC Championship game, Brown had a significant role. In Super Bowl 55 on February 7, 2021, played in Tampa in front of a limited crowd due to the COVID-19 pandemic, Brown caught a touchdown pass. The Buccaneers beat the Kansas City Chiefs 31-9. Antonio Brown had a Super Bowl ring. He had climbed back from the lowest point of his professional life and touched the highest pinnacle of his sport, and it still wasn't enough. Brown re-signed with Tampa Bay for the 2021 season. Over his first 5 games, he caught 29 passes for 418 yards and 4 touchdowns, production that reminded everyone of the receiver he could still be. Then he was suspended 3 games by the NFL for misrepresenting his COVID-19 vaccination status, having obtained a fake vaccination card. He returned in December, and the Buccaneers welcomed him back, partly because injuries had thinned their receiver core. On January 2nd, 2022, in a game against the New York Jets at MetLife Stadium in New Jersey, Antonio Brown's NFL career ended in a way so dramatic, so visible, so entirely in keeping with everything that had come before, that it felt almost scripted. In the middle of the third quarter, with the Buccaneers trailing and the game on the line, Brown walked up to head coach Bruce Arians on the sideline. There was a confrontation, brief, visible, captured on multiple cameras. Then Antonio Brown began removing his equipment. He took off his gloves. He took off his jersey. He took off his shoulder pads. He threw them to the ground. He walked shirtless along the Tampa Bay sideline, pointed at the crowd, flashed a peace sign, and jogged into the MetLife Stadium tunnel. He never played another NFL game. The Buccaneers released him 2 days later. Tom Brady released a statement expressing that he loved and cared about Brown, but that he was very concerned about his overall health and well-being. Brown responded by taking to social media to air grievances about Brady, about Brady's ex-wife Gisele Bündchen, about his agent, about anyone and everyone within reach. The bridges he had not already burned, he lit now. What happened to Antonio Brown after football is the story of a man who could not find a way to stop. He had no more football to run toward, no more defenses to beat, no more stadiums roaring his name. But the energy, the restless, driven, combustible energy that had made him great, did not disappear. It had to go somewhere. In 2022, Brown announced he had joined Kanye West's Donda Sports Agency as president, a role that lasted about as long as most things associated with Kanye West lasted in that turbulent period of the rapper's public life. In 2022, Brown was also accused of exposing himself to a woman at the Armani Hotel pool in Dubai, UAE, an incident he denied. Dubai will become a recurring location in the story of Antonio Brown's post-football life, a city where he seemed to find both business opportunity and a degree of removal from American scrutiny. In January 2023, Brown filed for Chapter 11 bankruptcy. Court documents listed less than $50,000 in assets, while acknowledging nearly $3 million in debts to 8 creditors, including more than $1 million in civil judgments. The man who had earned more than $80 million during his NFL career, who had signed one of the most lucrative contracts in receiver history in 2017, and then another major deal with Oakland in 2019, was essentially broke. In March 2023, Brown became part of the ownership group of the Albany Empire, an indoor football team in the National Arena League. He would later claim to be the 100% owner of the team. His tenure was marked by chaos, missed payments to the league, lawsuits, disputes with other team personnel, and the team's eventual expulsion from the NAL in June 2023 for failure to pay league dues and fines. He was also arrested in Broward County that same year on a warrant related to unpaid child support. He had 7 children by this point. An 8th was reportedly on the way in 2025. Brown continued to orbit the periphery of celebrity culture, appearing at events, posting to social media, floating trial balloon announcements about NFL comebacks that never materialized. In November 2024, he announced he wanted to play for the Pittsburgh Steelers for free for the rest of the season. The Steelers did not respond. He spent increasing time in Dubai, posting from hotel pools, posting from restaurants, living the kind of life that his social media accounts depicted as glamorous and that his bank account suggested was significantly more complicated than it appeared. And in Miami, a man named Zulkarnain Kwame Nantambu was watching. To understand the night of May 16th, 2025, you have to understand Zulkarnain Kwame Nantambu and the history between him and Antonio Brown that stretched back years before the shots were fired outside a Little Haiti boxing venue. Nantambu, 41 years old at the time of the incident, was not a stranger to Antonio Brown. The two men had known each other since at least 2022, and their history was not a history of friendship. According to court documents and defense filings and the subsequent legal proceedings, the relationship between Brown and Nantambu had been defined by confrontation. In Dubai in 2022, Nantambu was accused of stealing a pendant belonging to Brown. He was jailed for 30 days in the United Arab Emirates in connection with that incident. Back in the United States, Nantambu had filed a civil lawsuit against Brown over the matter, and a judge had initially awarded him nearly $1 million in damages before the case was later dismissed. In 2023, according to the defense motion filed by Brown's attorneys, Nantambu allegedly attacked Brown backstage at a Rolling Loud music festival concert in Miami. The motion claimed Nantambu had publicly threatened Brown, including a social media statement to the effect that, "Your days are numbered." Nantambu's account of this history, through his attorney, was sharply different. From the victim's perspective, Brown was the aggressor in their relationship, not the target. The civil lawsuit over the pendant was, in Nantambu's telling, a straightforward legal matter. The suggestion that he'd been stalking or threatening Brown was, in his camp's view, a legal construction designed to justify what happened on May 16th. It is worth noting who Zulkarnain Kwame Nantambu was in the public sphere. In February 2024, during Super Bowl 58 in Las Vegas, a man ran onto the field during pre-game ceremonies and unfurled a Palestinian flag before being tackled by security. That man was Nantambu. The incident made international news. Nantambu told the New York Post, in the aftermath of the May 2025 shooting, that he believed Brown thought he could shoot him without consequences under Florida's Stand Your Ground law. Brown, in Nantambu's telling, thought he would get what Nantambu called a free kill. It is a remarkable thing for a shooting victim to say, and it tells you something about the depth of animosity that had developed between these two men, a depth that investigators, attorneys, and ultimately a jury would have to wade through to find whatever truth lay underneath. The boxing event was hosted by Aiden Ross, the streaming influencer who had built a substantial following through his live events and celebrity boxing matches. The venue was a warehouse at 221 Northeast 67th Street in the Little Haiti neighborhood of Miami, the kind of space that gets repurposed for underground events, where the crowd spills indoors and out, where the energy is close and the security is improvised. Brown was there and live streaming his own presence, which meant that anyone watching his feed knew his exact location throughout the evening. According to his defense team, Nantambu was also watching. According to the defense, Nantambu was watching because Nantambu intended to confront Brown, and Brown's live stream had given him the perfect opportunity to find him. The prosecution's version was entirely different. Prosecutors and investigators, reviewing surveillance footage and the accounts of witnesses, saw Brown as the initiator of the violence. In their version, Brown spotted Nantambu and threw the first punch. Surveillance camera footage from the courtyard parking area around 11:55 p.m. shows Brown in an altercation with Nantambu and others. What is clear from the video, and what is not genuinely disputed by either side, is that a fight occurred involving multiple people. Brown suffered visible injuries, a cut near his eye, injuries to his knee and hands. Whatever else happened that night, the physical violence was real and Brown was on the losing end of parts of it. The defense described what happened next this way. Brown ran toward his car, trying to escape. He retrieved a firearm, one for which his attorneys emphasized he had a lawful concealed carry permit. He encountered Nantambu again near his vehicle. Nantambu made a threatening movement. Brown, believing his life was in danger, fired 2 warning shots intentionally aimed away from Nantambu. Nantambu then took Brown's gun in a subsequent struggle and fled the scene. Brown stayed at the scene. Brown cooperated with police. The prosecution described it differently. From their perspective, based on surveillance video and witness accounts, the fight was broken up by security staff. The confrontation was essentially over. Then Brown reached into the struggle and retrieved a black firearm from the right hip area of a security staff member, a move caught on surveillance camera. Cell phone video obtained from social media showed Brown with the firearm in his hand, advancing toward Nantambu on the outside sidewalk. 2 shots followed. Nantambu ducked after the first shot. The second bullet grazed his neck. He told investigators Brown had chased him down and shot at him at close range. Police arrived. Brown was in the parking lot with no weapon. 2 shell casings were on the ground. Witnesses said Brown was the shooter. Police detained him, walked him to a cruiser. In the body camera footage released months later as part of Discovery, Brown is heard complaining about his injuries, asking to use the bathroom, asking the officer to call his mom. There is no menace in this footage, just a man in pain and confusion, held in the back of a police car. The officers released Brown a few hours later. The alleged victim had not been identified. On the morning of May 17th, Brown posted to X. He described being jumped and robbed. He made no mention of shots fired. On May 21st, Nantambu walked into the police station and gave a statement. On June 11th, the arrest warrant was signed, and Antonio Brown flew to Dubai. The question of whether Antonio Brown fled to Dubai to avoid arrest or traveled there for legitimate business purposes before charges were filed became one of the most contested elements of the case before he was even brought before a judge. His attorney, Mark Eiglarsh, was unequivocal. Brown was not a fugitive. He had been in Dubai on and off for months, conducting business. He traveled to Dubai after the May 16th incident, but before the arrest warrant was issued on June 11th. He did not flee. He was not hiding. When investigators found him, he cooperated. Prosecutors pushed back hard. Assistant State Attorney Kimberly Rivera argued at a November 2025 bail hearing that Brown was aware a charge was coming when he left the country. His presence on social media in Dubai, openly posting photographs, appearing on streams, showing himself at restaurants and hotels, was in the prosecution's framing, not the behavior of a man who did not know he had a serious legal problem. It was the behavior of a man who believed he was beyond the reach of American law. Nantambu's attorney, Richard L. Cooper, was more pointed. He told reporters he believed Brown had gone to Dubai convinced he could not be extradited and had been publicly flaunting his presence there in the months following the shooting. By the grace of God, he was not killed, Cooper said to his client, and it was Mr. Brown's intention to kill him. The warrant specified a $10,000 bond with house arrest upon posting. Modest conditions that seemed to acknowledge Brown was not considered an extreme flight risk, or at least that the legal system had not yet caught up with the full weight of the charges. Then months went by. The warrant was issued in June. The summer passed. August, September, October. Antonio Brown remained in Dubai. His social media continued to update. In November 2025, the United States Marshals Service, working in collaboration with the Miami-Dade State Attorney's Office and federal partners, located Brown in Dubai. Exactly how that collaboration unfolded, which UAE authorities were involved, what diplomatic channels were navigated, was not fully detailed in public reports. What is known is that on November 6, 2025, U.S. Marshals took Antonio Brown into custody in the United Arab Emirates. He was placed on a flight. He did not fly directly to Miami. For reasons that were not fully explained by officials at the time, he was flown first to Essex County, New Jersey, where he was booked into the Essex County Correctional Facility. Jail records showed him there on November 6. He was then transferred to the Miami-Dade County Jail, where he arrived on November 11, 2025, and was officially arraigned the following day, November 12th. He appeared at his arraignment via Zoom, dressed in a red jail shirt, in a hearing before Circuit Judge Mindy Glazer. He entered a plea of not guilty to the charge of second-degree attempted murder with a deadly weapon. The November 12, 2025 hearing before Judge Mindy Glazer was, in miniature, a preview of the legal battle that would unfold over the months ahead. On one side was Assistant State Attorney Kimberly Rivera, who argued for pretrial detention. Brown was a former professional athlete. She contended with the means, the international connections, and a demonstrated willingness to leave the country to evade prosecution. He had been in Dubai for nearly 6 months, while a warrant for his arrest was outstanding. That alone, she argued, should disqualify him from any expectation of freedom while awaiting trial. On the other side was Mark Eiglarsh, a Miami-based criminal defense attorney with decades of experience in high-profile cases. Eiglarsh was quick, precise, and visibly confident. He pushed back on every point. Brown had no passport. Eiglarsh told the judge he had surrendered it. He would return his home in Broward County, right next to Eiglarsh's own office, his own home. Brown was the father of 7 children, with an 8th on the way in June 2026. He had deep family ties to South Florida. He was not a flight risk. He was a man who had returned home and was eager to clear his name. On the question of the Dubai trip, Eiglarsh was categorical. Brown had regular business interests in Dubai that predated the shooting. He traveled there after the May 16th incident, but before any charges were filed against him. He was not fleeing a charge that did not yet officially exist. He was conducting business. Both sides, in a moment of unusual courtroom candor, acknowledged doubts about the physical evidence. Both the prosecution and the defense raised questions about how, exactly, Zulkarnain Nantambu had been injured. Had the injury to his neck truly come from a bullet? Or had it come from the altercation itself? The melee of fists and bodies that preceded the gunshots? The prosecution accepted Nantambu's account that a bullet had grazed him. The defense suggested the neck injury was a scratch from the initial fight. Judge Glazer denied the prosecution's request for pretrial detention. She set bail at $25,000 and ordered Brown to wear a GPS ankle monitor and submit to house arrest with restrictions that would allow him to continue working and to remain present for his children. He was also ordered to stay 500 feet away from Nantambu and to stay away from the boxing venue in Little Haiti. The following morning, November 13th, 2025, Antonio Brown walked out of the Turner Guilford Night Correctional Center in Miami. He was met by Eiglarsh on the sidewalk outside. Brown embraced his attorney. He was carrying a bag with his belongings. They walked to a nearby food truck, where Brown got a drink, and then they left together in Eiglarsh's car. Someone filmed it. Of course. Someone always films it. Brown said a few words outside the jail. He thanked God. He said he was grateful to be home. He said he was eager to be with his family. He said very little about what came next. But what came next was already being set in motion. In the weeks and months that followed Brown's release, Iglarsh was busy. He spoke to the media with confidence that bordered on defiance. The charge was, in his view, a gross overcharge. Brown had not attempted to kill anyone. The prosecution would not be able to prove what they alleged. The self-defense argument was solid. The defendant, his attorney emphasized, was a loving, supporting father of 7. He had charity work. He had business interests. He had a community. He was not the reckless, dangerous man that the prosecution's narrative would make him. Richard Cooper, Nantambu's attorney, offered a sharply different assessment. He described Brown as an aggressor who had escalated a confrontation that was over and then pursued an unarmed man with a firearm. The self-defense argument, in Cooper's telling, was legally and factually untenable. The self-defense argument would have applied if the shooting had happened during that scuffle, maybe, Cooper said in a CBS News Miami interview. But what is undisputed here is that Mr. Brown then leaves the scuffle when it is over, and he comes back with a gun, and he starts shooting at my client. That sequence, the fight ending, Brown leaving, Brown return with a gun, was at the heart of the prosecution's case. If the fight was over when Brown retrieved the weapon and fired, then the claim of imminent self-defense became dramatically harder to sustain. Brown's legal team had an answer for this. 2. They argued that from Brown's perspective, the fight was not over. Nantambu had not walked away in Brown's telling. He had followed Brown toward his car, made an aggressive movement, and posed a continuing threat. The warning shots were not a pursuit. They were a final, desperate attempt to deter a man Brown had every reason to believe intended him serious harm. There was also a complication that Iglarsh addressed head-on, rather than leave for prosecutors to discover. Brown's status as a convicted felon. In 2020, Brown had pleaded no contest to a felony burglary with battery charge in Broward County, Florida, stemming from the moving truck driver incident in 2019. That conviction was on his record. In Florida, a convicted felon is generally prohibited from possessing a firearm. If Brown was indeed a convicted felon who was not legally permitted to carry a gun, that would raise serious complications for a stand-your-ground defense, since the law does not apply to someone who is engaged in criminal activity, including the illegal possession of a firearm. Iglarsh's answer was that Brown had received a concealed carry permit subsequent to the plea agreement, and that the plea was structured in a way that did not permanently bar him from firearm ownership. This was a legal argument that would need to be tested in court. On December 5, 2025, Brown's legal team filed a motion to dismiss the attempted murder charge in its entirety. The basis was Florida's Stand Your Ground law. The statute, enacted in 2005 under then Governor Jeb Bush, was one of the most debated pieces of self-defense legislation in American history. Before its passage, Florida law, like the law in most states, required a person who felt threatened to retreat if it was safe to do so before using deadly force. Stand Your Ground removed that requirement. Under the 2005 law, a person who is in a place they have a legal right to be, who is not engaged in criminal activity, and who reasonably believes they face the imminent threat of death or serious bodily harm, may use deadly force without any duty to retreat. The law further provides, crucially, for pretrial immunity hearings. A defendant who can demonstrate to a judge's satisfaction that their use of force was legally justified under Stand Your Ground can have all charges dismissed before the case ever reaches a jury. Florida's most famous Stand Your Ground case was the 2012 shooting of 17-year-old Trayvon Martin by George Zimmerman in Sanford, Florida. Zimmerman did not formally invoke Stand Your Ground in his defense, but the judge's instructions to the jury were shaped by the law's principles, and his ultimate acquittal was widely attributed to the legal framework the law created. The case ignited a national conversation about race, self-defense, and a law that has never fully concluded. Brown's motion presented a comprehensive and, depending on your perspective, either compelling or cynical recounting of the night of May 16, 2025. It laid out the history of violence between Brown and Nantambu in detail. The Dubai jewelry theft the 30-day jail sentence, the Rolling Loud attack in 2023, the public threats. It argued that Nantambu was not an innocent bystander who happened to encounter Brown outside a boxing event. He was, in the defense's telling, a man with a documented pattern of violence toward Brown, who had targeted Brown specifically on that night because Brown had been live streaming his location. The motion's description of the night read in part, Brown's use of force on May 16, 2025, was fully justified. Brown reasonably believed that the alleged victim intended to cause him serious harm. It described Brown running toward his vehicle, gun drawn, firing 2 warning shots intentionally aimed away from Nantambu. It said Brown intended only to deter further violence, not to injure or kill. It said Nantambu then took Brown's weapon in a struggle and fled with it, leaving Brown at the scene, which was why police found Brown without a gun. The actions he was forced to take were solely in self-defense against the alleged victim's violent behavior. Glarsh told reporters when the motion was filed, "We are confident that these charges will be dismissed as a matter of law." Richard Cooper's response was swift. He called the motion a farcical reimagining of what happened. He reiterated what surveillance footage appeared to show, Brown punching Nantambu, continuing to fight with others, and then, when the fight was being broken up and Nantambu was attempting to walk away, pursuing Nantambu with a weapon. The prosecution argued that even if Brown had a concealed carry permit, the sequence of events that led to the shooting disqualified him from stand your ground protection. Under Florida law, a person cannot claim immunity under stand your ground if they were the initial aggressor in the confrontation. If Brown to the first punch. As video appeared to show, the legal argument became considerably more complicated. He punched Nantambu in the face, a prosecutor told the court at one hearing, and then, along with 2 others, continued the attack. Nantambu walked away, and then Brown chased him down and shot at him at point-blank range. The question of who was the aggressor was not academic. It was a central question on which the entire case might hinge. In January 2026, portions of police body camera footage from the night of the shooting were released as part of the discovery process in the case. The footage showed Antonio Brown in handcuffs in the back of a Miami police cruiser in the immediate aftermath of the incident. He is visibly injured. There's a cut near his eye and he complains of knee pain throughout. He asked repeatedly to use the bathroom. He asked an officer to call his mom. At one point, he asked the officer to check the cut on his knee. He does not appear frightened in the footage. He appears frustrated, in pain, and bewildered. He says very little about what happened outside the venue. Also in January 2026, Local 10 News obtained and published surveillance footage from the courtyard parking area, showing the moments leading up to the shooting. The footage began around 11:55 p.m. and showed Brown throwing the first punch, landing a blow on Nantambu that triggered the larger fight. As the brawl expanded to involve multiple people, security staff moved in to break it up. In the surveillance footage, Brown can be seen in a struggle with a security staff member. And then, in what prosecutors identified as a key moment, Brown appeared to retrieve a black firearm from the right hip area of that security staffer. Moments later, Brown is seen walking around a white SUV. When he emerges on the other side, he is holding the gun. He begins moving toward Nantambu. 2 gunshots follow. Nantambu ducks after the first shot. Social media video captured the same sequence from a different angle. In that footage, you could see Brown with a firearm in his hand, advancing in Nantambu's direction. The shots could be heard clearly. This was the evidence the prosecution was building its case around. Not just a witness's statement, not just a shot spotter alert, but video footage from multiple angles showing the sequence of events. Brown's team had an answer ready. The defense motion maintained that what the footage showed was not a man hunting an enemy, but a man terrified of one. The struggle with the security staffer was Brown trying to arm himself in the face of ongoing danger. The advance toward Nantambu was Brown trying to reach his car and encountering Nantambu again unexpectedly. The shots were warning shots. The aim was deliberately away from Nantambu. And the fact that Nantambu ended up with Brown's gun, that, in the defense's telling, was the final evidence that Nantambu had been the aggressor. He had taken the weapon. Brown had not run. Brown had stayed at the scene. Brown had talked to police. 2 versions of the same night. 2 sets of attorneys. Two cameras pointed at the same moment, both claiming to show the truth. While the legal machinery of the attempted murder case ground slowly forward in the Miami-Dade courts through late 2025 and into 2026, the fuller portrait of Antonio Brown's life began to clarify in ways that were both sympathetic and damning in equal measure. Consider the financial picture first. The man who had earned over $80 million in NFL contracts, who had signed a 4-year, $68 million extension with the Steelers in 2017, making him the highest-paid receiver in football at the time, had filed for bankruptcy in 2024 with less than $50,000 in assets and nearly $3 million in debts. 8 creditors were listed. More than $1 million in civil judgments have been entered against him. How does that happen? How does a man earn $80 million and end up essentially penniless in his mid-30s? The answer involves some combination of the following: legal settlements, civil judgments, unpaid child support obligations across multiple family situations, business ventures that collapse, endorsement deals that evaporated in the wake of sexual assault allegations and behavioral controversies, a lifestyle that had been calibrated to the income of one of the NFL's elite earners and had not adjusted when that income stopped, the custom Rolls Royces that had been a training camp tradition, the jewelry that had become a calling card and a target, the lifestyle of someone who, after a childhood defined by insecurity and poverty, had become absolutely certain that the money would never stop. Brown also had 7 children, soon to be 8, by multiple women. Those relationships brought their own complications, child support disputes, domestic incidents. The particular strain that comes with fatherhood stretched across multiple households, with the demands of professional athletics replaced by the chaos of a post-football life. Mental health, too, was a subject that hovered at the edges of any honest accounting of Antonio Brown's story. After the shirtless walkout in January 2022, Brady publicly expressed concern about Brown's overall health and well-being, language that was widely interpreted as a reference to Brown's mental state. Former teammate Ryan Clark had described Brown's behavior in Pittsburgh as increasingly erratic in the latter seasons. The pattern of actions that seemed designed to sabotage his own career, the helmet saga in Oakland, the Mayock confrontation, the fake vaccination card, the sideline walkout, suggested someone for whom self-destruction was not a side effect of bad decisions, but possibly a symptom of something deeper. Brown himself never publicly addressed mental health questions in any sustained or self-reflective way, at least not in the years captured in this account. He preferred the language of grievance and resilience, the narrative of a man wronged by coaches, teammates, leagues, women, lawyers, reporters, to the language of introspection. But the people around him, the attorneys and former teammates and family members who spoke about him the months after the attempted murder charge, more than once mentioned something that sounded like anguish. He's a loving, supporting father of 7, with one on the way. Glarsh told the bail hearing judge. He has deep ties to this community. He plans to continue his business ventures and his charity work. These were things you say in a bail hearing to paint a picture of a stable, responsible client. They were also, it seems, at least partially true. Brown's relationship with his children, complicated as the circumstances of their various births had been, appeared to be one that he took seriously. The charity work in Liberty City, the food and mass distributions during the pandemic years, the PAL involvement before the Hollywood Police Department cut ties with him. These suggest a man who, somewhere underneath the noise, felt genuine obligation to the community that had shaped him. But caring about your children and your community does not insulate you from being charged with attempted murder. The law does not weigh a man's virtues against his alleged crimes. What the law asks is simpler and harder than that. On the night of May 16th, 2025, what did you do and why? In December 2025, Judge Marissa Tinkler Mendez set the key dates in the case. A hearing on Brown's Stand Your Ground motion was scheduled for June 23rd, 2026. If the motion was denied, if the judge determined that the law did not provide immunity in this case, the trial was set for January 11th, 2027. Judge Tinkler Mendez indicated she wanted to resolve the case before the end of 2026 if possible. The June hearing would be a pivotal moment. Under Florida law, at a Stand Your Ground immunity hearing, the judge can weigh disputed facts and make findings. This is different from a trial, where the jury decides factual disputes. At a stand-your-ground hearing, the judge acts as both fact-finder and legal arbiter. If Judge Tinkler Mendez determined that Brown had met the legal standard for self-defense immunity, the charges would be dismissed entirely, and Brown would walk free without a trial ever occurring. The stakes for Brown could hardly have been higher. A dismissal under stand your ground would mean freedom, the vindication of his legal team strategy, and the end of a case that had already cost him months of his life and what remained of his public reputation. A denial of the motion would send the case to a jury in January 2027. And at trial, Brown would face the full weight of the prosecution's evidence. The surveillance footage, the cell phone video, Nantambu's testimony, the shot spotter records, the ballistic evidence, the witness accounts. He would face a potential sentence, if convicted, of up to 30 years in prison. The 15-year maximum for second-degree attempted murder doubled by Florida's mandatory sentencing enhancement for use of firearm. Under Florida's 10-20 life law, a person who displays a firearm during certain violent felonies faces a mandatory minimum of 10 years. A person who fires a weapon faces a mandatory minimum of 20 years. 20 years mandatory minimum, 30 years maximum. For a 37-year-old man with 7 children, that is not just a prison sentence. It is a life. In the months between Brown's release in November 2025 and the scheduled Stand Your Ground hearing in June 2026, Eiglarsh's team was methodically building their case. They were still awaiting a report from a detective, a piece of discovery that had not yet been turned over by the state. The defense's strategy appeared to be multi-layered. First, establish the history. If the jury or the judge at the immunity hearing understood Nantambu's pattern of alleged confrontations with Brown, the argument that Brown reasonably feared serious harm became more credible. The Dubai jewelry theft, the Dubai jail time, the Rolling Loud attack, the public threats. If these could be established as a documented pattern of violence, they provided context for Brown's mental state on May 16th. Second, contest the sequence. The prosecution's version was, fight happens, fight ends, Brown escalates with gun. The defense's version was, fight happens, fight is ongoing in Brown's mind. Brown acts in self-defense. The surveillance footage was genuinely ambiguous about the interval between the end of the physical brawl and Brown's retrieval and use of the firearm. Any ambiguity worked in Brown's favor at a stand-your-ground hearing. Third, challenge the victim's account. Nantambu's credibility as a witness was not beyond question. He had a criminal history. He had his own pending civil litigation related to Brown. The defense would be expected to suggest that his account of the night, that he tried to leave, that Brown hunted him down, was shaped by his own interest in the outcome. Fourth, address the felon in possession issue. If prosecutors established that Brown could not legally possess a firearm, the stand-your-ground claim collapsed. The defense maintained that Brown's concealed carry permit was valid. This would require careful legal argument. Eiglarsh remained publicly confident. We are confident that these charges will be dismissed as a matter of law, he had said in December 2025. In January 2026, after the body camera footage and new surveillance video emerged, he maintained that position. Brown had acted within his legal rights. Richard Cooper, for Nantambu, remained equally confident. The video evidence, in his client's attorney's view, told a clear story that no legal motion could erase. Antonio Brown had punched a man, and when that man tried to walk away, Brown had followed him with a gun and fired. Both men walked into the same set of facts and saw entirely different realities. That was not unusual in criminal law. What was unusual was the magnitude of what was at stake. For Brown, for Nantambu, and for the question of how a life that had contained such extraordinary heights could arrive at such an extraordinary low. There's a photograph that circulated in the days after Brown's release from the Turner Guilford Night Correctional Center in November 2025. In it, Brown stands on the sidewalk outside the jail, a bag of belongings in his hand, dressed in street clothes for the first time in days. His attorney is beside him. Brown's expression is difficult to read. Relief, exhaustion, something that might be resolved. Behind him, the jail building recedes. Ahead of him, across the parking lot, a food truck is open for business. He walks toward it. He gets a drink. He leaves in a car. It is a mundane sequence of events. And yet there is something in that photograph that resonates. Here is a man who grew up with nothing in Liberty City. Here is a man who clawed his way to the top of one of the most competitive and physically demanding sports in the world. Here is a man who earned generational wealth and lost it, who won a Super Bowl and walked off a football field, who flew to Dubai and was brought back in handcuffs, who now wears an ankle monitor and sleeps in his own bed in Broward County, waiting for a judge to decide whether he will spend the next decade or two in a Florida prison. The story of Antonio Brown is, in some respects, a quintessentially American story. The kid from nowhere who makes it to the top through sheer, unrelenting will, the talent that is real and undeniable, the self-destruction that seems equally real and equally undeniable. But it is also something else, a story about what happens when the structures that might have caught a man along the way were never there, when a father was absent, when a mother did what she had to do, including sending her 16-year-old son into the street, when the trainers and coaches and teammates who saw the fire in him either couldn't or didn't help him learn what to do with it, when it turned inward. None of this excuses what allegedly happened on May 16th, 2025. If the prosecution's version is correct, a bullet grazed a man's neck. That man says he tried to walk away and was pursued. The law requires accountability for that. Whatever the backstory, whatever the grievances, whatever the history, but it contextualizes a trajectory. It helps explain, not excuse, but explain how a man with 7 children and a Super Bowl ring and $800 million in career earnings and 4 consecutive first-team All-Pro selections arrived at a jail door in Miami with a bag of belongings and a GPS monitor on his ankle. He always ran on the feeling of being wronged. The question was always, what happens when there is no one left to outrun? As of the beginning of 2026, the case of State of Florida versus Antonio Tavares Brown Sr. was proceeding on the timeline Judge Tinkler Mendez had established. The Stand Your Ground hearing was set for June 23, 2026. The defense was still awaiting the detective's report that remained outstanding in discovery. The prosecution was preparing to counter the immunity motion with the full weight of surveillance footage, witness testimony, and forensic evidence it had assembled. Brown remained under house arrest with GPS monitoring, living in Broward County, reportedly working on business ventures and spending time with his children. He had no passport. He could not leave the country. He was restricted from any contact with Nantambu and from the boxing venue in Little Haiti. Nantambu, through his attorney, continued to maintain that Brown had tried to kill him and that the Stand Your Ground motion was a legal maneuver disconnected from the facts on the ground. He was expected to testify at the June hearing, and if the case proceeded at trial, the legal community in Florida and around the country was watching the Stand Your Ground motion with interest. The outcome of a high-profile case could either expand or contract the practical application of the 2005 law in ways that would affect defendants for years to come. The question of whether a convicted felon with a subsequently obtained carry permit could invoke Stand Your Ground was one that had not been definitively answered at the appellate level in Florida. If Judge Tinkler Mendez granted the motion, Brown would walk free. The charges would be dismissed. Nantambo's civil options would remain open, and some form of legal contest between the two men would likely continue. But Brown's criminal jeopardy would end. If the judge denied the motion, the trial would begin on January 11th, 2027 in Miami-Dade County. A jury of Brown's peers would sit in a courtroom and hear the evidence. They would watch the surveillance footage. They would listen to Nantambu describe what happened to him on May 16th, 2025. They would listen to the defense's account. They would watch the body camera footage of Brown in the back of a police car, asking for the bathroom, asking for his mom, and they would decide, if convicted, the sentencing would follow. Under the 10-20 life firearm enhancement, a conviction on second-degree attempted murder with a firearm carried mandatory minimums and a maximum of 30 years. A judge would have some discretion within those parameters, weighing Brown's criminal history, his background, the circumstances of the offense, any statements of remorse or acceptance of responsibility, and the harm to the victim. Brown's 2020 felony no contest plea in the moving truck driver case was already on his record. His history of conduct violations, while most were civil or administrative rather than criminal, painted a portrait of a man with a long pattern of problematic behavior. These would likely be considered by any sentencing judge. Against that would be weighed the genuine accomplishments of Brown's career and life, the children who depended on him, and, if he chose to testify, the account of a man who grew up in difficult circumstances and spent his life fighting, sometimes brilliantly, sometimes destructively, against the world's assessment of his worth. The law is not always patient with context, but it is always, in the end, about facts. There's a famous story about Antonio Brown and why he chose jersey number 84 in Pittsburgh. 8 times 4 is 32. 32 teams looked past him. Every time he went out onto that field, the number reminded him of every scout who hadn't seen what he knew was there, every coach who hadn't returned his call, every team that had looked at the skinny kid from Liberty City and decided he wasn't worth a first-round pick or a second-round pick or a third, fourth, or fifth. In 12 NFL seasons, Antonio Brown amassed 928 receptions for 12,291 yards and 83 touchdowns. He was the most productive receiver in the NFL over any 4-year stretch during his prime. He made plays that will live in the highlight reels as long as the game is played. He made Pittsburgh roar on Sunday afternoons in ways that are still remembered by anyone who was in Heinz Field during those years. And yet the story does not end on a football field. It does not end with a retirement ceremony and a Hall of Fame speech and the kind of ceremony that the sport reserves for its greatest. It ends, or at least this chapter of it ends, in a Miami courtroom where a man in an ankle monitor is waiting to learn whether the rest of his life will be lived in freedom or in a Florida prison cell. In February 2026, a judge set the trial date for January 11th, 2027. The judge also scheduled a hearing for June 2026 to consider whether Florida's Stand Your Ground law would end the case before it began. The defense remained confident. The prosecution remained resolute. The evidence remained in dispute. Outside the courtroom, Aiden Ross had moved on to the next streaming event. The boxing venue in Little Haiti had reopened for other purposes. The cell phone footage of the night of May 16th continued to circulate on social media, viewed and argued about by people who had formed strong opinions in both directions. Brown continued to post to social media from house arrest. He spoke about his faith. He spoke about his children. He did not speak publicly about what happened outside that boxing venue. Nantambu healed. The bullets grazed had not ended his life, though his attorney had noted repeatedly that it easily could have. He was waiting for justice. His attorney was waiting for trial. And somewhere in Broward County, Florida, a man who grew up without a father in Liberty City, who was kicked out of his mother's house at 16 and bounced from couch to couch, who was drafted in the 6th round and became one of the greatest receivers in the history of professional football, who earned $80 million and went bankrupt, who won a Super Bowl and walked off a field shirtless, who flew to Dubai and was brought back in handcuffs. That man was wearing an ankle monitor and waiting for June. Waiting for January, waiting to find out what the rest of his life would look like. The number 84 is retired from no franchise. It hangs in no rafters. It has not been immortalized the way that numbers belonging to the truly great and truly finished tend to be immortalized. It is still out there, waiting to be claimed by the next man who needs a reminder that he was overlooked. 8 times 4 is 32. 32 teams looked past him. The question now was whether the justice system would look past everything: the talent, the fame, the childhood, the grief, the grievances, the bullets, and see only what happened on a sidewalk in Little Haiti, near midnight on May 16th, 2025. The answer was coming. It was always coming. As of March 2026, the state of Florida versus Antonio Tavares Brown Sr. is in the pre-trial phase in Miami-Dade County Circuit Court. Brown has pleaded not guilty to second-degree attempted murder with a deadly weapon. He remains on house arrest with GPS ankle monitoring and a $25,000 bond. He has no passport. He is ordered to have no contact with the alleged victim, Zulkarnain Kwame Nantambu, and to stay away from the boxing venue at 221 Northeast 67th Street in Miami. A Stand Your Ground immunity hearing is scheduled for June 23, 2026. If the motion is denied, trial is set for January 11th, 2027. If convicted of second-degree attempted murder with a firearm in Florida, Brown faces a mandatory minimum of 20 years in prison and a maximum of 30 years, plus a fine of up to $10,000. His attorney, Mark Eiglarsh, maintains that the charges are a gross overcharge and that Brown acted in lawful self-defense. Nantambo's attorney, Richard L. Cooper, maintains that Brown pursued an unarmed man and fired at him with intent to kill. The trial, if it occurs, will determine which version of that night a jury believes. The full story of Antonio Brown is not yet complete, whether it concludes in a courtroom in January 2027, or in a dismissal hearing 6 months earlier, or in some negotiated resolution that neither side has yet publicly acknowledged as possible. The final chapter has not been written. What is written, what will always be written, is a career of one of the most gifted athletes of his generation, the arc of a life that rose from nothing and burned at extraordinary temperatures, and the unanswered question that follows every extraordinary talent who falls, whether what broke them was something external, something inside them, or simply the long and inevitable weight of being human in a world that asked too much from them too soon and then walked away.